In case you don't know, the Portland Police Department is working hand in hand with Antifa, but this judge found them credible. They advise Antifa on how to avoid arrest. They're buddies. They allow Antifa to seek shelter behind them physically. Remember, the Constitution does not say that federal judges have a lifetime appointment. Those words are not in Article 3 or anywhere else in the U.S. Constitution. It says judges serve during good behavior. There's nothing to prevent Congress from doing a good behavior checkup every 5 years or sooner as warranted. How about that for a MAGA policy, which you could do with just a sheer majority of the Senate for removal for failing to serve during good behavior? Or we're just living in a judicial tyranny. All right, back to this. The protest outside the ICE facility between June 15th and 27th, generally uneventful with occasional interference to federal property. Obviously an abject lie. Although there were sporadic instances of unlawful behavior, federal law enforcement, along with local law enforcement, were able to manage the situation and arrest and prosecute those responsible for criminal conduct. But of course, when she says federal law enforcement, these were not the regular forces who would be in that office, in that facility to enforce immigration law. They had to fly in special forces, special response teams, not regular forces. In fact, according to trial testimony, remember, this is the trial testimony where the state of Oregon, the city of Portland, the state of California asked the judge to exclude their own police officer testimony that was favorable to Trump. According to trial testimony, the Portland police implemented new guidance on June 14th, including guidance for enhanced communication with federal protective services to assist with protests. Evidence showed the deputy regional director of the Federal Protective Service region responsible for protecting the Portland ICE facility was surprised to learn that the National Guard had been called out to deploy at the ICE building. The president has to consult with him? The deputy regional director that neither he nor the regional directors of the FPS made that request. Well, 12406 doesn't say the president can deploy if he cannot, with the regular forces, enforce federal law, if the deputy regional commander asks first. That's not what the statute says. And these are all, whether or not all of this was sufficient to ensure the safety of federal personnel and property, is not a judgment call that an Article 3 unelected, black-robed, tyrannical, inferior district trial court judge gets to make. It's not her call whether this was sufficient. The president makes that call. The commander-in-chief makes that call. More detailed findings of fact based on trial testimony. Remember, this judge knows that the standard is that the Court of Appeals, in evaluating her order here, is normally obliged to defer to her findings of fact. That's why she keeps saying that. The findings of fact based on trial testimony and exhibits are forthcoming following this court's full review of the record based on trial testimony. This court finds no credible evidence that during the approximately 2 months, that's her June 15th to July 27th, before the president's federalization order, protests grew out of control or involved more than isolated and sporadic instances of violent conduct. Why is isolated and sporadic? Why wouldn't that be sufficient? That the statute doesn't say unless they're isolated and sporadic. So there were instances of violent conduct, resulted in no serious injuries to federal personnel. Well, this is disturbing. This suggests that if there had been serious injuries, she might change her mind. So her determination relies on whether or not federal personnel get lucky and don't get killed or maimed, or get unlucky and get killed or maimed. They're being attacked by people with knives, bombs, arson, machetes, pistols, but they haven't yet suffered any serious injury. So this judge feels that that's fine. Nothing to worry about. The violence that did occur, so violence did occur. During this time, predominantly involved violence between protesters and counter-protesters, not violence against federal officers or the ICE facility. So as long as it's just innocent civilians being killed, that's fine. Although card readers at the ICE facility were occasionally damaged, this court found no evidence that any significant damage to ICE facility occurred in the 2 months, her cherry-picked dates, preceding September 28th. The credible testimony has not shown ICE was unable to effect arrest or otherwise perform the agency's duties. We're supposed to believe that all these attacks, the knife attacks, the impeding of the vehicles, the arson attacks, the explosive attacks, the mortar attack, the bomb threat, the attacks armed with a Glock, the machete attack. None of this was impeding the agency's ability to perform its duties. Although the evidence so far showed that protesters frequently blocked the driveways, the evidence showed federal law enforcement were able to clear the driveway. How would you feel if you were, every time you left your house to go to work, go shopping, you drove out of your driveway, and first you had to clear the driveway of protesters? Would it be fair for you to say, you know what, my ability to leave and return to my home is being impeded? I'm unable in my regular manner to get to work, to go shopping. Even when the building closed from mid-June to early July due to property damage that occurred on June 12th, conveniently outside her cherry-picked dates, ICE's Enforcement and Removal Operations Office was able to temporarily relocate to another facility in Portland for administrative purposes until the building reopened. ERO officers were still making arrests in the community. All right? This is another lie they tell. They say, well, you're not unable to enforce the law if you're able to enforce it at all. So if normally you would have been able to make 1,000 arrests in some period of time, and these protesters, these terrorists, with their knife attacks, machete attacks, bomb attacks, mortar attacks, arson attacks, bomb threats, firearms attacks, these protesters are able to, out of 1,000 times, prevent you from making what would have been a straightforward arrest 999 times, but you're still able to make one arrest out of 1,000, well, then you're not unable to enforce the law. You're still able to do it. You're only able to do it once out of 1,000 times, but you're still able. These officers were still making arrests in the community. Who gets to decide how substantively their ability to make arrests was impaired? I would suggest that should be their boss. The elected Article 2 executive branch president, commander-in-chief, buttressed with the delegation of militia authority given to him by the Article 1 Congress, not an unelected black-robed tyrannical inferior district trial court judge, Article 3 judge. Based on these preliminary factual findings, and this gets me too, she's willing to enjoin the president, enjoin the elected Article 2 executive branch president when he's attempting to secure the safety of federal personnel and property based on what she describes herself as preliminary findings. She's willing to violate the separation of powers, assume for herself the Queen's crown of commander-in-chief based on what she herself necessarily must admit are preliminary findings. This court concludes the president likely did not have a colorable basis to invoke Section 12406(3), not able to enforce the laws, or Section 12406(2), rebellion or danger of rebellion to federalize and deploy the National Guard to the Portland ICE facility. As to the former, the Ninth Circuit held in Newsom that although Section 12406(3), unable to enforce the laws with the regular forces, does not have as a prerequisite that the president was completely precluded from exercising the relevant laws of the United States, minimal interference is not enough to invoke 12406(3). So who gets to decide minimal interference? Again, I would suggest it's the democratically elected Article 2 executive branch president and commander-in-chief, not an unelected black-robed tyrannical inferior Article 3 district trial court judge. The relevant question is whether the president had a colorable basis to conclude that protesters' activity significantly impeded the ability of federal officers to execute the law. Who gets to define significantly impeded? Same answer, my friends. Here, the facts on the ground establish that since June 14th, her cherry-picked date. Why June 14th? June 14th was a date of tremendous violence. And she says since June 14th, so she doesn't have to account for that. Is the president bound to ignore June 14th? Of course not. Since June 14th, the protests outside the Portland facility did not significantly impede, again, the judge is using her judgment in place of the commanders-in-chief, the ability of federal officers to execute the immigration laws. Trump argues it would be perverse to effectively fault the president for waiting to authorize the Guard deployment until late September rather than deploying the Guard immediately in June or July. In other words, hey, we could have done it June 14th, the day of hyperviolence. You're punishing us for being unnecessarily more patient than the law requires. But this judge says the Ninth Circuit's contextual reading of 124063 and Newsom confirms that a sustained change in the facts of the ground is relevant in assessing the president's determination. As the Ninth Circuit explained, the statutory context confirms that minimal interference with the execution of the laws is not by itself enough to justify invoking 124063. I would suggest this would mean, like, if you're making one arrest out of 1,000 and somebody tries to stop you from the crowd, tries to interfere, that might be minimal interference. That's not what's happening here. Knives, machetes, bombs, arson, mortars, guns, none of that is minimal interference. Then the Ninth Circuit just misread the statute, presumably, maybe stupidly, maybe deliberately. They say subsections 1 of 2 of 12406 describe unusual exigencies, invasions, not happening here, and rebellions that threaten the normal operations of civil government. If this court, but 12463, unable to enforce the laws with the regular forces, does not require an extreme exigency. They just choose to impute the extreme exigency of sections 1 and 2 to section 3. Why? There's no basis for doing that. If the court were to accept defendant's argument that any past exigency could justify a determination the president's presently unable to execute the law, then 12463 would swallow sections 1 or 2 because invasion or rebellion renders the president unable to exercise some laws at some point. They're all alternative criteria. Congress did not write them like this by accident. For similar reasons, plaintiffs are likely to succeed in demonstrating that defendants violated subsection 12406-2. That's the rebellion or danger of rebellion. Let's see, I believe she's just going to say here that it applies to overthrowing the entire government. First, a rebellion is organized. Well, these people outside the Portland facility are obviously organized. They have food, they have water, they have shelter, they have medical care, all arranged. So they're clearly organized. A rebellion must be made up of multiple people. Well, there's multiple people. They're dressed in uniforms. Third, the group must engage in armed hostilities. Knives, machetes, guns, arson, bombs, mortars. Clearly, this armed facilities. And fourth, the common purpose of a rebellion is to overtake an instrumentality of government by unlawful or undemocratic means. Is that not happening? Are the Antifa terrorists outside the ICE facilities? They're not breaking the law? They're only engaging in democracy? Historical examples of rebellion confirm this definition. Take the Whiskey Rebellion. Well, how is this any different than the Whiskey Rebellion? The Whiskey Rebellion was a rebellion against a tax on whiskey. At the height of the conflict, several hundred insurgents. Well, there have been a couple of hundred insurgents, protesters, terrorists at a time in this facility. The insurgents fired upon federal officers. We've had mortar attacks, bombs thrown. Let's see. The federal district court was unable to sit. And anyway, Washington was authorized to ride forth on a horse he personally led several states' militia to put down the Whiskey Rebellion. How is it any different than here? Shays Rebellion, 15,000 rebels, sought to annihilate all debts, public and private. Again, the Ninth Circuit has dealt with this. Just because a prior rebellion took 15,000 doesn't mean, and by the way, a rebellion is not required. A danger of rebellion is sufficient. The statute provides for a danger of rebellion. This court, of course, found credible the testimony of the Portland Police Bureau command staff. In case you don't know, the Portland Police Department is working hand in hand with Antifa. But this judge found them credible. They advise Antifa on how to avoid arrest. They're buddies. They allow Antifa to seek shelter behind them physically when they're attacking federal law enforcement officers. But that's who this judge finds credible. She says the protests in Portland at the time the National Guard callouts, again, she's making an arbitrary choice, cherry-picking dates, are likely not a rebellion. But who gets to make this call? Supposed to have tremendous deference to the president. Is that happening here? Of course not. are not likely a rebellion, do not likely pose a danger of rebellion. They are obviously actively engaged in rebellion against the federal enforcement of our immigration laws. There's no realistic contesting of that. The trial testimony included evidence of sporadic, isolated events of violent behavior. So there's violent behavior. Who gets to make the judgment call of whether sporadic, violent, isolated events are enough? Same answer. Violent behavior towards federal officers and property damage to a single building. So it would be different if it was multiple buildings. Again, who gets to make that call? Defendants have not offered any evidence demonstrating these episodes were perpetrated by an organized group engaged in armed hostilities for purposes of overtaking an instrumentality of government by unlawful or Democrat. I mean, this is just facially a lie. Clearly, they're organized. They're Antifa. They're wearing uniforms. They're there every day. They're engaged in armed hostilities, and they're attempting, of course, to overtake the instrumentality of enforcement of immigration law. Once again, in the 2 months leading up to the federalization order, her own cherry-picked window of time, the majority of violence. So again, I mean, this is a judgment call. Why does she get to make the judgment call of how much violence is too much? That did occur involved violence between protesters and counter-protesters, isolated sporadic incidents of low-level unlawful conduct. I read you the list, folks. The bomb threats, the mortar attacks, the arson, the machete attacks, the Glock pistol attack. The trial testimony produced no credible evidence of any significant damage to the ICE facility in the months before the president's call out, and no credible evidence ICE was unable, she means completely unable, to execute the law. The officers were able to clear the blocked driveway. Same nonsense we already talked about. And some defendants are likely to demonstrate that defendants' federalization was ultra vires. She means, what an idiot. She means the plaintiffs are likely to demonstrate that Trump's federalization of the National Guard was ultra vires under 12406. And if it was ultra vires, it violates the 10th Amendment. I mean, that logically follows, of course. If it was unlawful, it violates the 10th Amendment. But it was not. It was not unlawful. So on likely to succeed on the merits, she gives the win to California and Oregon. And really, that's the only one that matters. All these others are just make work. Irreparable harm. There's no irreparable harm. Balance of equities in the public interest. No one really cares about those. We just pretend that we do in the law. Finally, defendants requested a stay. Hey, could you pause this preliminary injunction until we have the actual trial, the full-blown trial on the merits? Pending resolution of the appeal of this court's first TRO, the Ninth Circuit stayed that first TRO that allowed federalization of the National Guard, but not deployment. So they can't actually do anything. So they serve no purpose. This court now stays the preliminary injunction to the extent it enjoins federalization of the National Guard, but it still does not allow, but not deployment. So again, there's no purpose to having them. It's like saying you can start your car, but you can't drive anywhere. For the above reasons, this court issued the following preliminary injunction until this court issues a final opinion on the merits, which could take months or years. That won't happen, of course. The Supreme Court will have an answer back probably by the end of the month. Resolving plaintiff's request for a permanent injunction, Defense Secretary Hegseth is preliminarily enjoined from implementing the following memorandum and deploying the National Guard in Oregon. We don't have to read the list. It allows federalization, but does not allow deployment. Signed yesterday, Judge Karen J. Immergut.